freedom of speech,
fundamental rights,
freedom of conscience,
academic freedom,
freedom of press,
and the right to listen.
You're listening to So to Speak, the free speech podcast, brought to you by FIRE, the Foundation for Individual Rights in Education.
Okay, very good. Welcome back to So to Speak, the free speech podcast, where every other week we take an uncensored look at the world of free expression through personal stories and candid conversations. As always, I am your host, Nico Perino, and I'm very excited for today's conversation because I get to talk to one of my friends, Luke Morgan. He is a recent graduate from Duke University School of Law and was on the student newspaper with me at Indiana University, the Indiana Daily Student. We were on the editorial board together where we'd often butt heads on various issues, but often had a kind of weird bipartisan alliance. So Luke, welcome onto the show.
Thank you, Nico. Thank you for having me. Yeah, I was just remembering our kind of strange cross-ideological alliance and the joys of having a 10 a.m. Sunday deadline to turn your column in.
Yeah, right. And for our listeners, I guess it's probably important to point out, I came from a very libertarian perspective in college, in my columns in particular, but also when we were discussing the editorials that the newspaper would write for any given day. And you came from more of a liberal progressive outlook. And the funny thing about being a libertarian, or always being a libertarian, is you sometimes agree with conservatives, you sometimes agree with progressives. And there was even, I remember, like a pretty red or a pretty communist guy on our editorial board who I sometimes agreed with as well. But it was a fun time, and I don't know how much of that they get at the Indiana Daily Student these days. Unfortunately, I don't read it as much as I used to, but that was really a nice opportunity for me to talk with people who I disagreed with and really hone my ideas and in some cases change my ideas, which is
I totally agree.
Which is what this is all about. So, Luke, I don't remember when we were at the IDS, the First Amendment being a particular interest of yours. I remember, obviously, you had an interest in press issues because you worked for a student press. But when did First Amendment issues start to interest you? In particular, you've written 3 articles. You've published 2 law review articles, one in Hastings Constitutional Law Quarterly, and where's your gun one published?
That was my student note in Duke Law Journal. Okay,
very good. Well, I'll link to it in the show notes, and then you have one on the Free Press as well coming out that's still in a working draft formulation. But when did you start getting interested in these issues?
Yeah, it's actually interesting. I think you're right that it wasn't a big focus of mine in undergrad, but my first kind of exposure and where I first became interested in constitutional law really was actually my senior year of high school in debate at a national tournament that we had my senior year of high school. The topic was in the United States, freedom of religion has wrongly evolved into freedom from religion. And, it's a big national tournament, 250 teams. And then it breaks to the top 32. And once you're at that point, it takes obviously 31 rounds to get to the champion.
So you're debating 31 times the same motion?
No, right. So it's top 32. So to get to top 16, you have to do 16 rounds. Plus 8 rounds for the next. So there's 31 total rounds to get to a champion. And out of those 31 elimination rounds, the team arguing against the topic, saying that it hadn't wrongly evolved into freedom from religion, won 29 rounds. And the team arguing for the topic won 2 rounds. And that team both of those rounds were myself and my partner. And we actually won them by arguing that the Bill of Rights should have never been incorporated against the states under the 14th Amendment, which nobody really knew anything to do at the time. That's not something that I think a lot of people had prepared for on the topic.
Uh-huh. So you won because the other sides, in a sense, hadn't really considered your perspective yet.
Yeah, it was. We kind of approached it orthogonally instead of arguing necessarily about the substance. But the point being, that was my first introduction to the First Amendment and to constitutional law generally, and I sort of really dived in at that point, and that was a big inspiration for me. And then when I get to law school in 2016, 2017, I actually become a research assistant for Professors Joseph Blocher and Daryl Miller, who were working at the time on a book on the Second Amendment. And so I kind of started my DLJ piece on guns and free speech as a Second Amendment project that picked up some First Amendment stuff. But I think my passion is primarily in the First Amendment area.
Yeah, so you've got 3 articles here, and I'd like to start with the gun one, because that, I believe, is your first one, and is also perhaps the most, it's a topic that a lot of people are talking about these days, and you said you started at law school in 2016, correct?
Yeah.
It was the next year, 2017, that, of course, the events occurred in Charlottesville, where white nationalists marched on Lee Park to protest against the removal of the Robert E. Lee statue. They had arrived the evening before. This is in August, and I think they arrived August 11th. The protest was set to take place on August 12th. August 11th, that Friday, they marched through University of Virginia's campus with lighted tiki torches. And then the next day they arrive, many of them looking like an armed militia. There were some on the other side of the protest protesting against them, who also arrived armed, and it looked like an occupied city, Charlottesville did at that point. And we all remember the outcome. There were a couple of outcomes. A number of people died. There was Heather Heyer, of course, who was struck by an automobile and murdered. But there were also, I believe, 2 deaths for police officers who died in a helicopter crash. And there was a big discussion at that time about the guns that were so clearly on display at that protest. Now, I live in Virginia, and in Virginia, you're allowed to open carry and I believe conceal carry a weapon. And then the question became, are you allowed to do that in the course of demonstrating? Like, does the First Amendment protect that right? And if not, in states where you have a statutory right to carry, can they create prohibitions in the course of you exercising your First Amendment right? So if you can carry normally through the streets, can they stop you from carrying in the course of a protest? The idea being that the carrying of the weapon might be symbolic speech. It might be expressive conduct. So your article tackles this, essentially arguing that there is no First Amendment right to carry a firearm as expressive conduct, correct?
Correct. The kind of main point of the First Amendment part of the article is that, we have a Second Amendment. Let's just analyze stuff about carrying guns under the Second Amendment and keep things kind of in a sensible order, or.
Yeah, and what is the Second Amendment? So insofar as the Supreme Court has said anything about it, what does it protect right now?
So right now, the Second Amendment, the court hasn't said too much about what the Second Amendment right protects. You have District of Columbia versus Heller, which says that the Second Amendment is about self-defense, and therefore it protects at a minimum the right to bear a handgun for self-defense purposes in the home. And then you have McDonald versus Chicago, which says that that applies to the states as well, because of course DC versus Heller is in DC, so it's a federal issue. And then you have a kind of strange little opinion called Caetano versus Massachusetts, where the Massachusetts Supreme Court said that the Second Amendment right extended to stun guns, I believe, because they weren't around at the time of the founding. And the court, I think, without saying necessarily that it does extend to stun guns, says that that's not that it's not limited to guns that existed at the time the Second Amendment was authored. And so that's the universe of modern Second Amendment cases, post-Heller cases. And then you have the New York State Rifle and Pistol Association case, which just came out.
And what did that case say? Did it answer any questions that might come to bear on this First Amendment question?
So that's a big question. Decision isn't out yet, but the question is whether or not it was mooted because the city repealed the law, and then the state passed a law saying that the city could never pass that kind of law again. So it was a law that more broadly prohibited guns. I think it was like a transportation of guns outside the home issue. And it was a fairly restrictive kind of, this is what you see with second litigation, is that a lot of these cases, Heller and McDonald, were both very much outlier laws that were struck down by the court. And this was kind of similar. But so yeah, while the litigation was ongoing, the law was repealed and then preempted at the state level. So it looks like it may be the majority of the court is going to say that it's moot. But there was some resistance to that, so that's the big question there.
Gotcha. So now let's talk about, I want to kind of approach this systematically. Let's talk about the history of the use of guns in political protests, because Charlottesville and the white nationalists, the militia groups who arrived there, were not the first type of political demonstrators or first kind of political demonstrators to use guns in protests. This kind of goes back over a century, essentially, and you cover some of this history in your article. Can you talk a little bit about that?
Yeah, so one of the things I talk about in my article that I kind of found a fascinating juxtaposition is that one of the main Second Amendment, one of the only Second Amendment cases before Heller is this case called Illinois versus Presser, or Presser versus Illinois, which comes up from the Illinois Supreme Court, and it's about socialist German immigrants in Chicago. So you have, after the Civil War, basically, you have a wave of European labor comes to the United States, and industrialization is happening. And there are, I think everyone knows, kind of just absolutely brutal working conditions. And this is where, kind of in this milieu, is where the progressive movement gets started, and it's where the unionization movement gets started. And as workers are kind of militating for better working conditions, the National Guards start to be created. And at the time, these National Guards were financed by the industrialists and the businessmen. And there was a pretty overt cooperation between the government of the United States and the military of the United States and the wealthy industrialists to shut down these unions. And the United States as a whole has an extremely kind of violent labor history, and a lot of it happened at this time. I cite one source in the article that says that the United States has the most violent labor history in the Western world, other than Russia. And I actually think that source was counting the Russian Revolution in Russia's column. So I think excluding that, we might be number one. But there was violence on both sides. You have a lot of people who were unionizing were attacked, and they fought back. And so Hermann Presser is a German socialist immigrant in Chicago, and he forms, not him, but he and his compatriots form a group called, I don't want to pronounce the German, but it was called the Education and Defense Association, and it had an explicit mission of protecting their right to unionize and to fight for better working conditions against the state-endorsed violence. And so one of the things that they did was they marched. They armed themselves with, in kind of a traditional, like, late 19th century military regiment would arm themselves, and they marched. And Hermann Presser rode at the front of the march with a cavalry sword at his side and was arrested for it. And he made First and Second Amendment arguments.
And the court ultimately said that he didn't have a First and Second Amendment argument to make to defend the right of carrying those arms, correct?
Right. I guess you would say technically the court's holding was, at the time, the First and Second Amendment didn't apply against the states. They hadn't yet been incorporated against the states. But the court did provide some substantive feedback on this kind of exercise of the rights, and it expressed a lot of skepticism. It said that the exercise of the power to ban armed marches by the states is necessary to the public peace, safety, and good order. To deny the power would be to deny the right of the state to disperse assemblages organized for sedition and treason, and the right to suppress armed mobs bent on riot and rapine.
And that wasn't the first time or the only time that these sorts of groups agitating for rights have been armed. I mean, probably the most well-known example are the Black Panthers, who who all over the country and in California would carry arms.
Yes.
And then you also have, I believe it was like the Defensive Justice League in the South during the civil rights protests. They would carry weapons. But in these cases, it doesn't seem to me that the carrying of the weapons is expressive. It seems more defensive than expressive. Would you say? Yeah,
I think that this is part of the difficulty, is that there's a little bit of both. For example, I think in the case of Presser, it was very explicitly, I think they said that the purpose of the armed march was to show the Illinois militia what they could do. And so that's kind of a message that I think that you hear echoed today in kind of the armed demonstrations that you see primarily among like more right-wing gun advocates who accept the insurrectionist theory of the Second Amendment, that the reason that gun ownership is protected is to check government tyranny. So you do see people today who explicitly tie their gun possession and their open carry in public to that kind of interest. I do think that with a lot of the examples that you're talking about, however, there is an instrumental purpose as well. And that's one of the difficulties with First Amendment analysis of gun possession, and why I say, in part, we should just leave guns to the Second Amendment, where you can take a look at all of these interests. Because if you're looking at it from a First Amendment perspective, how do you look at something that is both an instrument, a tool, with a specific purpose, and it also may be communicating a message?
Yeah. So let's kind of leave that question to the side right now, because it's actually a theme that runs through at least two of your articles, and maybe this other one about addiction. The idea that because of the emphasis the court has placed on the First Amendment, the importance that it's given to it, and the sort of high bar that the government must reach in order to violate or to restrict any expressive rights, a lot of other rights within the Bill of Rights or other rights within the First Amendment have been brought within the speech clause. And we'll get there at the end of this conversation, because I do want to talk about your article on a free press, which you argue that the press clause of the First Amendment has kind of the doctrine behind it has been truncated in a certain sense, because a lot of it has been wrapped within the free speech clause. But that's a common theme that runs through your articles, which is that all these doctrines need to be developed, and we can't just rest on one clause of one amendment to answer all the questions. But on the question of expressive conduct, now the Supreme Court has sort of developed a test to determine whether conduct that is expressive or has an expressive component how it should be analyzed under the First Amendment. It says that it has to meet two standards. It says the actor intends to convey a particularized message, and it is likely that those who view the conduct would understand the message. And in your article, you give one example that I'd like to read out for our listeners. Richard Burgess went to a pool hall wearing a pistol and a holster on his hip, as well as a shirt which quoted the Connecticut State Constitution regarding the right to bear arms. He also had copies of a brochure examining his organization's position on the legality of carrying firearms. After refusing multiple requests to conceal his weapon, Burgess left the bar. Police had already been called, and he was arrested for disorderly conduct, a charge which was later dismissed. Burgess subsequently filed a complaint against the police departments. The court held that because reasonable officers could disagree on whether it was likely that others would recognize the man's message, the officers were entitled to qualified immunity. And this is what the court says. While plaintiff's shirt makes it more likely that those who viewed his overall conduct would understand his message than if he were only openly carrying his weapon, it was unclear that his possession of the gun was a particularized message. But his message regarding the Second Amendment, rather than, for example, a message or a weapon carried for protection. You had some brackets in there, so I kind of botched the reading of it. But anyway, the outcome of that is that because people might, or an officer or a citizen might not understand exactly what his message was. It could just be that he was carrying a weapon, or it could be that he was sending a message about the Second Rights. It's not clear what message about the Second Amendment he might have been sending. The police officers were entitled to qualified immunity. Now, the qualified immunity question might muddy the waters in the analysis here, but in reading that, I thought if that's not expressive, if that doesn't meet the bar for expressive conduct, it seems as expressive as conduct can get. Like I'm thinking about Morris v. Frederick here. That's the case stemming out of Alaska with a group of students on a field trip holding up a sign that said "Bong hits for Jesus." And in that case, the court ultimately held that their expression wasn't protected, but in the course of doing the analysis, they tried to bend over backwards to imbue that banner with some sort of message. They constantly asked the students' lawyers, like, what was the message that the students were trying to send with "Bong hits for Jesus"? Was it advocacy for marijuana legalization? Was it some sort of religious message? And ultimately, I mean, the case sort of rested on the fact that the students could not articulate a message. So I'm seeing that case in which the court's bending over backwards to try and get a message out of the students. And in this case, there is some sort of message being sent, but they're dismissing it. So could you talk a little bit about that case and how we should think about it?
Yeah. So I think that this case, you're right to pick it out. I think it's a very instructive example about kind of the difficulties of applying expressive conduct. So as you said, you have the two-pronged test. Did the speaker intend to convey a message, and were people likely to understand that message? Now, there is a little bit of a twist on that, which is that it's more of a question of were people likely to understand that the speaker was trying to convey a message, as opposed to were people likely to understand the speaker's message. And depending on, basically, I think the court and the facts, you're going to see the emphasis in one direction or the other. But I think the correct test is, would people understand that he was trying to convey a message at all? So, for example, in Texas versus Johnson, the court said that obviously burning a flag is protected speech. But the court pointed out that we don't necessarily know in every instance what message burning the flag is intended to portray, but it's intended to portray a message, clearly. And so turning back to this issue, you have this gentleman who's, he's got these brochures and he's got his T-shirt with the Connecticut State Constitution regarding the right to bear arms, and he's got a gun in a holster on his hip. The question is, I mean, is he just a guy who's both passionate about guns and happens to be carrying one right now for his own protection. And this is something that Caitlin DeBoer, who wrote a pretty similar article to mine in the Hastings Constitutional Law Review, she pointed out that you can't divorce the instrumentality of the gun from its carrying. You know, when people are carrying a gun, they are carrying a weapon, a tool, and you can't ignore that fact when you're looking at someone who's claiming that their possession of a weapon was expressive. So you have that aspect, and then there was one other kind of similar aspect, which is that the court has said, they've never necessarily rested an opinion on this, but the court has said that where expressive conduct is understandable primarily through reference to other supporting speech that is happening, that is where someone is getting a message or is understanding the intended message of some conduct, but they're understanding it through something else that's happening in the same area, then the expressive conduct test is not met.
So the context of the expressive conduct matters. Like, is it happening, for example, at a rally for the Second Amendment? Right.
I think that the example that my First Amendment professor always used was, you have a bunch of people sitting around under signs that say legalize marijuana, and one of them starts smoking a joint. Mm-hmm. You know, maybe they're intending to express a message, but if you took away the signs that say legalize marijuana, you just have someone smoking a joint in the park. And so if you have to rely on signs or something else for people to understand your message, then your conduct isn't, I guess it's not expressive enough.
That's actually a great parallel, because the thing I'm struggling with here is that the carrying, well, actually, maybe it's a little bit different, because I'm just thinking about the marijuana example. And in Virginia, for example, you can carry a weapon, open and conceal carry a weapon, I believe. And then the question becomes, can the state regulate that right in the context of engaging in expressive activity? But the marijuana example is different, because smoking a joint, use Virginia for example, in public is illegal in the state of Virginia. But can the state regulate it if it's in the course of expressive, like a demonstration? I would say probably yes, or almost certainly yes. So you have you have pressures coming from different sides in there.
Right.
But let's say that you're in California, you're smoking a joint legally in public, and you're doing it in the course of expressive, like a demonstration. Could the state regulate the smoking of that joint? Let's say if you're just doing it in the course of like a protest, because if you can do it in the context where you have a statutory right to the conduct in any other context, can the state then regulate it just because it's occurring in an expressive context? It's an interesting question, and I hadn't thought about it that way before.
Yeah, I think that you get into a little bit about the unique characteristics of guns once you get.
Yeah, because then you bring in this last question, which is kind of the thrust of your article, which is, in the context of guns, you have sensitive places, and you argue that demonstrations are sensitive places where the state must have, or should have, or could have more authority to regulate things that might pose a danger to the people in the area.
Mm-hmm.
Right? And maybe with marijuana, you don't have that same danger, although you could argue, and I think the state might overcome the burden, that secondhand smoke is a danger, and it's in that context that they can regulate just smoking a cigarette too.
Mm-hmm. So my argument for sensitive places is actually a little different. There hasn't been necessarily a theory of, I guess, so for background context, the court in Heller, in addition to stating what it viewed as the baseline gun right, which is about self-defense, and then it stated that, whatever level of scrutiny you apply, a prohibition on handgun ownership for self-defense in the home is constitutional. The court then said that this decision should not be read to out on, and then provided a list of regulations that just so happens to track almost exactly the list of federal gun regulations. And among them, it said that their decision should not be read to any doubt on prohibitions of guns in sensitive places like government buildings and schools. And obviously that list is not exhaustive, and the court's not exhaustive. And that the sensitive places language captures a lot of gun regulations in the United States today. And despite that, there hasn't really been a settled idea of what the court means by sensitive places and what else are sensitive places other than governments and schools. And so I argue that sensitive places, I don't necessarily think the court meant it this way, but sensitive places makes a lot of sense if you talk about it in the context of places where the presence of guns will undermine First Amendment protected activity. And that's government buildings, that's schools, that's rallies and demonstrations, universities, public parks, places like that.
So I thought, and this is maybe where you and I might have a little bit of disagreement, before you kind of present that argument, you go through some of your student comments or your reviewers' comments about what they thought might be or should be the doctrine for sensitive places in this context. There was one student who I think recommended sort of like a time, place, and manner analysis, which of course is very common just in the demonstration context in First Amendment analysis. And then there was another student, Jordan Pratt, who also suggested something similar, but more of a traditional forum analysis in determining what a sensitive place might be. And to the extent that there are government buildings or there's government property where historically there's been a broad right to carry firearms, then perhaps the right to carry a firearm in expressive or non-expressive activity should be allowed there. And I don't know whether national parks, for example, have been places where historically you can carry weapons, but I know, for example, that there are some people who camp and like to have a weapon, but that doesn't look in the expressive concern that we have here. But your argument about how the marketplace of ideas is best served, I mean, if we're talking about First Amendment values and bringing a First Amendment analysis to bear on those values and how they intersect with others, to the extent that value is important, the presence of guns limits the exchange of ideas because it might induce fear on behalf of those who would otherwise participate in the democratic process. Now, my big critique of that, and I think it's the critique that most gun owners would have, is that it's the presence of guns by people lawfully carrying them that makes them feel safe in certain environments. For example, I know I have a lot of Jewish friends who now attend synagogue with armed guards present. There was that case in Texas a couple of weeks ago, or maybe a month ago, where a man came in with a assault-style weapon, shot off once, and then was immediately taken down by a security officer. And there were a number of other parishioners who had their guns trained on him. And a world where I think, and I don't have the statistic right in front of me, concealed carry weapon owners have a lower incidence of crime than even the police, I believe. People would argue, well, unless you have a complete ban on weapons, then the only people who have weapons who could bring them into these sensitive places would then be criminals, and the disarmed public, law-abiding public, would be at their mercy, and perhaps, you could argue, less inclined to participate in First Amendment protected activity like, a church congregation.
Yeah, so that's interesting. I think, I guess I would start out by I guess my argument is keyed a little bit to the idea of, you think in a rally, context, for example, or a demonstration context, the idea of there being a lot of guns concentrated in a single place amongst these rally goers or amongst these people, the idea that has a distorting effect on the marketplace, in that, threats of violence historically are a relatively persuasive tool. Maybe not necessarily in the long term, but certainly in the short term, threats of violence work. And so if we allow our political discourse to become one where the possession of or making your point through the barrel of a gun is acceptable, then that's going to distort the marketplace of ideas, because it amounts to a subsidy, basically. If you take the marketplace concept seriously, which I have general skepticism of the marketplace of ideas metaphor as it works, but if you take it seriously, allowing the presence of guns to make political points at political demonstrations, for example, or at government buildings is troublesome, because it encourages or incentivizes the use of carrying a weapon to make a political point and to make a political argument. And my point is that these political debates are extremely important and extremely necessary to have, and that includes the political debate over the meaning of the Second Amendment and the appropriate level of gun possession in the country. And to make the political debate or the outcome of that debate a function of who has the weapons is a distortion of the marketplace of ideas, which doesn't lead to good outcomes. Now, when it comes to, for example, armed guards in schools or synagogues or government buildings, I think that that's more of a question of empirics to me. Does it work or does it not work? And I think that there's some question about whether or not open carry or concealed carry, and whether or not broad public ownership works or doesn't work at stopping mass shootings, or whether it makes things worse or doesn't make things worse. So those are empirical questions to me. I think that in terms of the effect on the First Amendment and on First Amendment interests, which are kind of paramount in our political system, that broad use of guns to make political points, to win debates, is what I'm focused on and what I find troubling.
Yeah, one of the challenges, so baked into that argument is the idea that there are people who would be, so I think we can both agree that the firing of a weapon, if not done in self-defense, clear self-defense, during one of these demonstrations can and should be outlawed. You can't shoot off guns in the air. But I think what you're arguing more or less is that the response by some people to seeing the guns would create fear and then might discourage them from speaking up, correct?
Yeah, that's part of it. And that has a distorting effect on the debate. I think it also leads to questions about access to democracy. I think, for example, I don't know if you've seen the images from Kentucky this past weekend, but certain people are allowed to walk into the Kentucky State House, wearing masks and with rifles, and certain people aren't. And that's troublesome too.
Yeah, just kind of a sidebar on that is I saw it reported somewhere. I don't know if it's true, but if you're coming into the Kentucky State House with a weapon, you don't have to go through the metal detectors. But if you aren't carrying a weapon, then you do. I found that to be kind of funny in a sense. But my big concern about that sort of regulation on expression, the regulation of expression based on the responses of people to that expression, is that I don't like giving the government the power to determine what speech can be restricted based on someone's subjective reaction to that expression. So for example, going back to our earlier conversation on whether a message could be properly understood, I don't like the idea that someone has to understand my message in order for my message to be protected. Like, does it need to be super literal? Does it, the clothing I'm wearing, for example, says something, it's expressive in a certain sense, might say something about me, but what if that message is misinterpreted? What if people have different reactions to it? And you could, of course, throw in an objective standard in there, but do you really want an objective standard in analyzing speech or expression? I don't know. I think part of speech and expression in certain cases is that the message isn't clearly understood. But then, also the worrying about other people being fearful of your message. I mean, civil rights demonstrators, marched through towns in the South, and people in the South were fearful of how that might change their towns. And I would argue, and I'm sure you would, that the message that those civil rights demonstrators were trying to send and the change that they were trying to inspire was good. But the whites in those towns were fearful of it. So I'm always weary of giving the power to government to censor based on those sorts of subjective reactions. I don't know if that's a general sentiment of yours as well, but it's kind of changed by the unique instrumentation of guns.
Yeah, I think that's definitely part of it. So part of the reason why I think that this works as a theory of sensitive places for the Second Amendment is that it's a relatively objective question. Mm-hmm. Is this a place where the presence of guns could lead to essentially private censorship or a distortion of the activity that is meant to take place in that area? And I think that provides for a little more objectivity. Mm-hmm. I think that one of the points that I try to make here is that people wouldn't use, if you think that marketplace theory is correct, people wouldn't use guns to make political points unless it worked. And if that's the case, then either everyone's going to have to start using guns to make their political points, or the ideas that need guns to win the debate in the marketplace of ideas are going to win out. And I think that either of those is not a good result. Those are two of the results. The third possibility is that, the persuasive power of the threat of violence just disappears. And I don't think that, that's a thing that we can place a lot of hope on. So I think that the first two things, either everyone's going to start needing guns, or the ideas that need guns and can't win without guns start to win, neither of those are good possibilities. And so I think that the answer is to just let's have the political debates, including the political debates about guns, but we don't need the guns to make the points in the political debates. Mm.
Yeah, it's hard to put yourself in I've never protested with a gun. It's hard to put yourself in the shoes of people who do, whether it's done primarily to intimidate political opponents or to actually send a message, and the potential political intimidation isn't baked in there. But interesting concepts to think. I've been doing this podcast for over 3.5 years, and I feel like I've talked about everything under the sun having to do with free speech and the First Amendment. And a lot of the doctrine is settled in the First Amendment. That's one of the reasons I like talking about campaign finance law, for example. Is the more complex issues, especially where rights intersect with other rights, make for interesting discussions, and this is one that makes for very interesting discussion. You have two other articles, though, so I want to move on to those. But if any of our listeners are interested in reading this one, it is online. I'll link it in the show notes, and it's called Leave Your Guns at Home, The Constitutionality of a Prohibition on Carrying Firearms at Political Demonstrations.
One of the worst subtitles.
You need to have a subtitle, though, although your next article that we'll discuss doesn't have one.
Yeah, so many syllables.
Yes, yeah. It needs to have a rhythm or a rhythm to it. So this one is Addiction and Expression. And this was an interesting article as well. It's kind of a novel approach on whether expression that can be addictive can be regulated under the First Amendment. So, okay, kind of as a background here, well, I'll let you explain the background. You start by explaining the history, which is that things that are addictive have historically been regulated in America. So, like, what things?
Right. So I talked a little bit about this. Tobacco and alcohol have both very unique political histories in America, and there's been, probably trillions of words written about the political histories of alcohol and tobacco in America. But I do talk about regulations of addiction in American history. And so alcohol, for example, in the early 1800s, the United States was the drunkest country on earth, and we drank something like 3 times the modern rate of alcohol. And less than a century later, we passed Prohibition. And what happened in that century was people came to believe in alcohol addiction. And that was the motivating factor in Prohibition, was the deleterious effects that alcohol addiction had on families and on society. And that's what led to Prohibition, which was a prohibition on the manufacture and sale of alcohol. And then with tobacco, you have, again, I think the recognition that nicotine is addictive was a game changer. So you had tobacco executives saying throughout the 20th century, including up to 2005, arguing that nicotine was not addictive, which was a lie. They knew that nicotine was addictive much earlier than that. But after Congress recognized and after they somewhat gave up on arguing that nicotine wasn't addictive, that's the first time that Congress grants the FDA the regulatory authority to prohibit the sale of tobacco in certain situations. Before that, it was almost entirely controlled by congressional statutes. So those are 2 examples. And then the third is gambling, which is kind of the most on-point example. And gambling has a very interesting history. Gambling was the first form, or lotteries, I guess, were the first form of taxation in the United States. They paid for UNC, they paid for roads, they paid for government buildings. Thomas Jefferson called them taxation on the willing. So they were really heavily favored, but at the same time, private gambling was restricted. Since the Mayflower landed, private gambling has been restricted in the United States. And if you look at the reasoning that was given at that time, it was because people recognized that gambling was addictive. Before there was really a clinical understanding of what addiction was, people were talking about how gambling controlled people's minds and was irresistible. And so the point that I try and make here is that the recognition that something is addictive or can be addictive really represents a fundamental game change in how we treat that activity, that substance, whatever it is, because we take addiction seriously.
Yeah, and there's a history in America of regulating addiction. But in your article, you tackle it in the context of expression. There is some sort of expression that can be addictive as well. And if that expressive conduct or that expression is addicted, can you regulate it under the First Amendment, which I think is very interesting. And you focus on 2, mostly 1, but 2 areas. One area is pornography, which has been found to be addictive. And the other area is video games, in particular loot boxes. So explain what those are for our listeners.
Sure. So loot boxes are something that were invented in 2005, 2007, right around there. And it is now 2020, and they are in 95+% of video games.
And gamers hate them. Well, some do, because they force you to spend more money.
Yeah. So that's really the point. Gamers absolutely loathe them. They're horrible. So I guess to give, having passed judgment on them, I will now explain them. Loot boxes are essentially a purchasable lottery ticket or a purchasable gamble within the game. And it can come through in-game currency, or it can come through real-world currency, dollars and cents, or it can come through in-game currency that is purchased by real-world currency. And so basically, you pay the video game, whatever it is. I think, for example, in this game, Apex Legends, there are like $1 each or something like that. You pay the game $1, and it sends you back a loot box. And then the loot box, you click the button to open it, and it explodes in this brilliant, kind of firework of confetti and noise and all this stuff, and you get some items out of it. It might be like a different color of armor for your character, or a skin that goes on your gun, or like a little whatever, like a tag or something like that. And so traditionally, the biggest resistance has been, if you can purchase it with real money, it can't affect the quality of gameplay. It can't make you more competitive against other players. But that's and I talk about this in the piece, that line is being pushed by developers almost continuously, despite the fact that gamers have repeatedly set these hard red lines. They just keep getting moved and moved and moved. And the reason that they keep getting moved and moved and moved is that loot boxes are addictive. They're gambling. And so despite the fact that everyone hates them, people still buy them.
Yeah, the gamble is that you don't know what's going to come in that loot box. And there's something in the circuitry of our brain where things are where unpredictable things are addictive.
Yes, and this has been, it's in the circuitry of all animal brains, basically. This is called the Skinner box experiment. He would have animals press a button to get a treat. And those who got a treat every time they pressed the button would keep doing it for a while. He'd stop giving them treats. They'd press the button a few more times, and then they'd give up. And then he had a different set of animals who he would give them a treat randomly when they pressed the button. So not every time, but at random intervals. And then he would cut off the treats. And the ones who were given treats randomly would continue pressing the button for hundreds of times. And that's what we're doing with loot boxes, basically. And they are, as I said, they're something that has just infested, basically. It's hard to think of it as anything other than just this infestation throughout all of video games. And so, yeah, my article is about, like, this stuff is intentionally addictive. I mean, the video game companies aren't being very good at hiding the fact that they are trying to make people addicted to their product. And so what should we do with that from a free speech perspective? Because video games are protected speech.
Because the courts have ruled that code is speech, or can be speech, historically.
Right. And in Brown versus Entertainment Board or something like that, I just think of it as Brown at this point.
Dealing with violent video games, right?
Yeah. Brown versus Entertainment Merchants Association. The court said it wasn't even litigated. The court says California correctly acknowledges that video games qualify for First Amendment protection.
So if code is speech and some code can be addictive, I worry that focusing so narrowly on video games is kind of impossible, because there is a lot of code or expression that can be addictive. I mean, you kind of tip your hat to it in the article, but Facebook's algorithm for its newsfeed is addictive. Social media is addictive. Your telephone is addictive. Television can be addictive. I mean, and they have psychology to keep you watching. For example, they put the big climax before the almost climax right before the commercial, and you have to watch through the commercial in order to figure out what happens. At Jeopardy, for example, they'll go to commercial just before they reveal some sort of big thing that you've kept watching for. So is regulating addictive expression pretty much opening the door to regulating television? I know there have been complaints historically when radio first came out that kids would just sit in front of the radio instead of reading their books or doing their homework or playing with their friends. I have a hard time determining where the limiting principle would be there, because so much of successful expression, or expression that people want to engage with, is because of the addictive nature of it. And addiction, of course, can sit on a spectrum. But I wanted to get your response to that.
Yeah. I'm fairly upfront, I think, in this article about this being the big challenge, is that the things that make us addicted to video games, or the things that are placed in video games intentionally to addict us, are, social scientists, what people have described as vectors of addiction include like advanced graphics and leveling up and social aspects of the video games, and quests and missions and stuff like that, where you get a reward at the end. These are all things that make video games playable, but they also, at a certain extreme, make them addictive. And so that is the big kind of in deciding to whether or not you can regulate addictive expression, is because if you ban everything that's addictive about a video game, you're left with something unplayable. So you're right that it is this kind of the central animating tension here. And I talk about, pop music on the radio. You have people complaining about how it sounds algorithmic. That's because, there are successful equations for putting out a successful pop song. The same is true with Netflix shows. They have a list of things that make people binge watch these shows. And so there are formulas. And that's something that David Courtwright talks about in his book that I quote, called Age of Addiction. He says we're living in something he calls limbic capitalism, where essentially corporations are across the board, and his is much broader than mine. He talks about food, for example, are increasingly relying on neuroscience and brain chemistry to make their products addictive. And so I think you're right that there is a concern about over-regulation and under protecting things. But one of the ways that I address that is by saying that the speech needs to be intentionally addictive, to be taken out of the realm of protected speech. So it should be, for example, loot boxes are they serve two functions: to addiction and to get money out of players. And so where that's the case, those I think are safely taken out of the realm of protected expression.
But still, I mean, most good expression is intended to be addictive. Like the television producer is intending to put the big event right before the commercial, so you watch afterwards. So does there have to be some sort of like pervasive nature of it, or is like, because the television program is only 30 minutes, you don't have to worry about someone wasting their entire week watching the television program? I
think that I see a little bit of a difference there. I think that what the television producer is doing in that case is to make people stay through the commercial break, but it's also, there's artistic purpose behind cliffhangers and stuff like that.
Cliffhanger, that's the word I was looking for.
we recognize and enjoy that. I think that, like I said, with loot boxes, for example, just a plague whose purpose is to exploit predictable, irrational neuroscience, predictable, irrational brain activity to cause people to give the developer more money.
Yeah, and you kind of quote some people who have been hooked on these video games as saying, I don't want to, but I can't help it, essentially.
Right. And so I guess the other thing I would say about that one of the things I find so fascinating about the First Amendment generally is that the First Amendment, like the rest of the Constitution, is an exception to democracy and an exception to democratic lawmaking. And what's fascinating about the First Amendment is that It is an exception to democracy in large part to protect democracy. And so, my inclination is that I think we can, I don't want to say trust, but I think we can rely on democratic processes to distinguish between intentionally addictive, deleterious speech and speech that it causes something to be enjoyable and may at certain extremes have addictive tendencies. But I think we're capable of kind of distinguishing between the two.
So at the end of your article, you argue that regulation of addictive expression is permissible under the First Amendment, and you don't carve out a new exception for it. You try and place it within the incitement standard, correct?
Mm-hmm. I do think I argue for treating it as a new exception.
Oh, do you? Okay.
Intentionally addictive speech. But I also argue that based on what the court has said in Stevens, that the exceptions need to have some sort of basis in history and tradition, that addiction looks a lot like incitement. And that's how you get kind of an exception for addiction through the court's preferred process of using history and tradition.
Yeah, and the court's, I think what you're referencing in Stephen is the court's reluctance to create any new exceptions to the First Amendment not already outlined. Stevens, of course, was the Animal Crush videos case. And then in there, I forget who wrote the majority. Was that Kennedy?
I can't remember.
Yeah, but the opinion essentially said they didn't want to create a new exception for the First Amendment. Now, last question on this one, because I know we're already at an hour and I still want to take 10 minutes if you have the time to talk about your press article. But the last question on this one is, in your article, you talk about movement in Congress to ban loot boxes or to regulate video games. But that movement within Congress would be targeted at those games which are marketed towards minors or children, correct? And so my question for you is, and you argue that that's kind of a fool's errand because minors will still have access to these video games, their parents can buy it. I mean, anyone who was under 18 and saw an R-rated movie by themselves, knows how easy it is to gain access.
And that's what the court said in Brown, too. That's one of the reasons the regulation in Brown got struck down, was because, someone's dad could still just go buy the video game for them. Yeah.
So in thinking about that, I wonder about the constitutionality of just outright bans of loot boxes. And actually, your faculty advisor, Joseph Blocher, if I'm pronouncing his last name correctly, I've only communicated with him over email, but he has a whole article about the constitutionality of bans. And talking about the history of addiction, in order to outright ban alcohol, they had to pass a constitutional amendment. So I wonder about the ability to ban loot boxes or addictive expression writ large in that context. Can you just have an outright ban that's not a more narrowly tailored regulation without a constitutional amendment?
So that's one of the interesting things to emerge from Brown, is that Brown is based on under-inclusivity, which is kind of a strange decision, and it's gotten a lot of critique, and it seems like the court has walked it back a little bit. But the decision in Brown was about violent video games, and California banned the sale of them to minors. And the decision in Brown was written by Justice Scalia, who said that under-inclusivity was enough to defeat this legislation, because California banned minors from purchasing violent video games, but they didn't ban them from purchasing violent books or from watching violent television shows or violent movies or anything like that. So Justice Scalia read that as kind of singling out a disfavored speaker, video game developers. That's kind of a strange decision. Generally we want, and this is what Chief Justice Roberts said when walking that back a couple years later, which is that we want Congress or legislatures to legislate with care here, and to speak in very narrow kind of prohibitions where they're regulating speech, especially. We want them to be as narrow as possible, don't we? And so I think that what I do when I'm talking about this legislation, which is the prohibition, it's the PCAGA, and it's about banning loot boxes in children's video games. What I do is I say, let's just look at a ban on loot boxes, period. Mm-hmm. And I think that passes strict scrutiny. I think that it's a ban on loot boxes is narrowly tailored. It's targeting a very specific subset of speech with a very specific intent behind it to cause people to spend money and to produce addiction. And I think it serves a compelling interest. The state has, and that's kind of where I tie in the history of addictive regulations, is that the state has a compelling interest in making sure that in avoiding the consequences to society of addiction writ large. And so with regard to just flat out bans, I haven't made it all the way through Professor Blocher's article, but I think that in this context, the question is either A, could this ban satisfy strict scrutiny? And I think it would. And then B, my argument is it shouldn't have to, because there's not really a good reason to protect intentionally addictive speech. I think the only reason that we would end up protecting it is kind of the concern you raised about an empirical question about whether we're able to draw the line properly. Yeah. And that question in many ways is like the big question in First Amendment jurisprudence, right? Is we can't really draw lines very well, so we're going to overprotect. I think that intentionally addictive speech, especially in this context, it's a line that we are, capable of kind of figuring out.
Well, that article is Addiction and Expression. It was in Hastings Constitutional Law Quarterly, I think the most recent issue. That's volume 47, number 2 of winter 2020. And I will link that, of course, in the show notes. I encourage all of our listeners to give it a read, because it goes deeper than just this superficial conversation we've had here. It also talks about pornography. Banning pornography was a big conversation in the late 80s and early 90s, and it's come up again. And this article might inform you on how to think about some of those questions. But I want to take just 10 minutes here, because I know I've kept you longer than I promised I would keep you, to talk about an article which I won't be able to link to for our listeners because it's not yet up on the internet. It's still in a workshop form. But the article is called, tentatively, in draft form, The Broken Branch, Capitalism, the Constitution, and the Press. And I'm glad you wrote this article, Luke, because it's stuff that I've been thinking about a lot recently. And I was recently speaking at a high school in the DC area in which there were some free press advocates on the panel. And they made the argument essentially that the press clause of the First Amendment should be given more robust consideration than it currently is. Right now, the courts have essentially not developed much doctrine around it, because most of what we would be considered press activity can be covered under the free speech clause of the First Amendment. But you take the situation happening with the press today, which is to say that a lot of people are losing their jobs. You write that in the last 15 years, more than 1/5 of local newspapers, more than 1,800 newspapers, have disappeared. You write that between 2008 and 2018, the 5 major news industries, newspaper, radio, broadcast, television, cable, and other information services, shed 28,000 jobs, or about 25% of industry employment. I went to journalism school. Makes me glad that I didn't end up becoming a journalist. It seems like a very unstable profession right now. But you argue that this has a problem for democracy and that it can be addressed through the First Amendment. So if you want to bring us a little bit through the background of this article.
Yeah. So I guess the background of the article is you have what you just described happening in the news industry. I think it's underappreciated what's happening. It is an utter collapse. Something like for example, in 2000, advertising made up 80% of newspaper revenue or news organization revenue, with circulation being 20%, and that was kind of the standard through most of American history since the advertising system developed in the 19th century.
And when you say circulation, you mean people who subscribe and pay a monthly subscriber
fees are 20%. So it's 80-20 advertising and subscribing. That's 2000, up until 2000. In 2015, so just 15 years later, they're equal. Advertising's 50, circulation is 50. And in 2018, circulation is now I think it's 60-40 circulation to advertising, and it may even be more extreme.
And it's not just because the press has gotten better at getting subscribers, it's because they're losing advertisers.
Right. Circulation has declined in that time. So that's what's happening. Advertising has disappeared. And as a result of it, basically advertising was almost a direct subsidy of the news. It's an intervention between the subscriber and the producer of the news, where the subscriber agrees to look at advertisements in order to pay less for the news. So that the collapse of advertising has led to a complete economic collapse of the press. And so I look at that, and not a lot of people are talking about that as an economic issue or as a crisis in journalism. Not a lot of people are talking about it as a constitutional issue. And I think it is a constitutional issue because the institutional press, these organizations that produce quality journalism, and that includes, reporting and commentary. The institutional press the existence of that was a background assumption of the Constitution. The framers were explicitly clear over and over again, first of all, that press freedom was one of the most important rights in the Constitution, and they really liked newspapers. They often hated the newspapers of the time, but they liked the idea of newspapers, and they viewed the existence of this institutional press to act as a check on government power and on private power, as a precondition of a representative democracy. And I think that just the collapse of the institutional press is a lot like if tomorrow there was no Senate. How would the government function? If the Constitution looked exactly the same, the government needed 2/3 of a Senate majority or the president needed 2/3 of a Senate majority to confirm somebody, but there was no Senate. How would we function? And I think that's what's happening with the institution.
Well, you quote from Thomas Jefferson in the article, who famously said that if the choice was between a press and a government, he would choose the press.
Yeah, and I think we should take that literally.
Yeah.
Well, when you the newspapers of the time.
Oh yeah, they a lot of the writings at that time that were the news industry, journalism standards hadn't quite been fully developed. So it was a new medium. So you had people doing lots of different things, including there were lots of ad hominem attacks. The fight between John Adams and Thomas Jefferson, if you want to read some of that fight and how it occurred in newspapers, broadsheets, they were calling each other horrible names.
Yep.
But at the same time, I do agree that I think it was a background assumption that there would be a functioning press as a check or a watchdog of government. Indeed, the debate over the Constitution happened in the press when you think about the Federalist and Anti-Federalist papers. But you essentially argue if capitalism cannot support a free press, and I think you're right in saying that at least so much of it for me is hard because I think journalism lost a golden opportunity in the 90s to prevent a situation like today happening. I think it was poor thinking. I think if most of the industry, and I don't know if there would have been antitrust considerations here, had went to a paywall model in the 90s, then they might have survived because they would have conditioned people from the onset of the internet that they can't rest on advertisers or other people to pay for their news content. It would have valued it more. And you almost need everyone to do that, because if there are a couple newspapers that are going to not have a paywalled environment, people would flock to those perhaps. Or they should have developed like a micropayment system. And I know they're like Apple is working on this right now, where you pay one clearinghouse to read a bunch of different newspapers, and that clearinghouse apportions your monthly $9.99 to the newspapers based on, I don't know, viewership. I just think the business model could have been more thought out had people not been status quo bias on behalf of the publishers who always thought the advertising.
They all thought the internet was going to be a flash in the pan.
Yeah. So, but I mean, let's take for granted for the sake of this discussion that the situation is bad for newspapers. There are some counties in America that don't even have a newspaper. So you have some county governments without any like institutionalized watchdog. Now there might be individual bloggers who watch this stuff, and we might not categorize them as press, but let's take for granted in this case that the press is in decline and they haven't been very good at figuring out a business model that will help them survive. So the question then becomes, if this is baked into the Constitution, it's an underlying assumption of the government, does the press clause create a proactive role for the government to come in and save them?
Yeah, so I think that, to start at the top, I guess, the argument I'm making is that there isn't really a market case for journalism. It's a public good through and through, and tons of positive externalities that, and economists have studied this and quantified this, really, tons of positive externalities that the news organization, and I don't want to focus just on newspapers because, I don't know that there needs to be a world of print necessarily. But the government, so there's tons of positive externalities that the news organization can't capture, or at least there's not a good way for them to capture it. And so there's not a business model for journalism is my argument. And I think that I don't necessarily get into the doctrinal consequences of that in this paper. I'm more focused on arguing that it is a constitutional problem. And as I say, at some point, somebody should do something about this. I think that if you were to take my idea of the press clause seriously, which my idea of the press clause is basically that it protects press freedom. Press freedom is about protecting or about scrutinizing and checking private and public power, and creating an institution capable of meaningfully doing so. That requires more than just of what we think about as non-interference on the government's part. It requires meaningfully that institutions be able to exist, and that includes an economic way for them to exist. And so I think that once you get into doctrine, my belief as a policy matter is that the government needs to fund journalism. My belief as a matter of press clause doctrine is that there's the potential, if you accept my version of the press clause, that certain things might be constitutional that we would think of as probably violating the free speech clause today. So, for example, limits on consolidation and private ownership that undermine the independence of the newspaper from certain private power. Right now, we have some ownership limits of the press, but that's based on the broadcasting capacity or the fact that they use the public airwaves. Yeah. So it's not as much of a constitutional problem. I think that if the press is about, if press freedom includes economic security, as I argue that it does, then that might mean that Congress is empowered to, or is not prohibited by the First Amendment from taking actions to shore up economic security, as long as it doesn't undermine the independence and informative.
But isn't that wouldn't that be very unique in the Bill of Rights, or in particular the First Amendment? You conceptualize the First Amendment as an enumeration of negative rights, that is prevention or restrictions on the government. We are free to do things and the government cannot. But your conceptualization of the press clause might require positive rights. That means proactive interference in the government, by the government, or I don't want to use a loaded word like interference, but proactive action by the government to secure a right, which it just isn't really how the First Amendment's conceptualized.
Yeah, traditionally. I think you're right. I don't know that I'm necessarily strictly arguing for some kind of affirmative obligation on Congress's part to fund journalism, although I think that would be, to me, as long as you put it in an endowment or something like that so that there's not the possibility of it being taken away. I think it would be an unambiguously good policy for Congress to do that. I'm not necessarily arguing for that affirmative obligation. I think that you're right in saying that my argument does differ from the traditional kind of conception of the First Amendment as embodying negative rights, because I think it's less of a positive right than a structural guarantee of the Constitution that this institution exists, and whatever it takes to make sure that institution exists. It's, for example, like, we need to build a building to put the Senate in. Something like that. We need the institutional press to exist to have a functioning democracy. We're seeing the negative consequences of the lack of, a shared reality emerging from a strong institutional press. And I think that relatively aggressive interventions in the market are merited.
So is it possible? Well, so let's start. I want to take this a little bit systematically. Two questions here, or one question, and then I have another follow-up question based on your answer. Is one of the reasons that the press clause, and you go through how the press clause doesn't have a lot of jurisprudence backing it up because it's kind of been baked within the free speech clause. Because the Supreme Court doesn't want to recognize the press as an institution. And I think for some very good reasons. The idea being that to recognize it as an institution means to actually recognize the activity of news gathering and in order to do that almost functionally, you need to determine who journalists are. And by determining who journalists are, having the government do that, you almost need to create a licensing system to do that. And there's just skepticism based on like kind of the libertarian nature of our Constitution of government licensing protected activity. So it's hard to define what the press is. And there's a danger, I think, in doing so. I don't know. I want to get your take on that first. Yeah,
I think that the argument that I make is that the courts worry about creating a special class of journalists, for example. I haven't seen it stated by the court in terms of a concern about, creating a licensing system specifically. I've seen it more kind of on the other side as, why do journalists get more rights to speak than other people? I think that concern, I argue, is misplaced because this isn't about the free speech clause. There's a whole nother clause of the Constitution, the press clause, that is about the press. And I argue that the press clause, based on the history of the revolution and what they were saying at the time, as well as just kind of a normative kind of analysis of First Amendment and making it all fit together, the press clause is about protecting the institutional press. And so the concern about singling out the press as a matter of free speech doctrine, I think is, very apt. I don't think we should necessarily single out speakers. However, there is a whole other clause that is about the institutional press and was intended to have meaning.
Well, it's not necessarily about institutional press. I mean, it just says, Congress shall make no law abridging the freedom of speech of the press. So it could be, I just wonder where like bloggers who have done a lot of good in reporting, especially, and you see this a lot in the local context, filling the void of institutional press, bloggers reporting on the local goings on of their government. So I would wonder, and perhaps it doesn't need to take a licensing format, but creating as the court loves to do, a 3-pronged test for determining what news gathering activity actually is, and then making that kind of the definition of the press.
Yeah. So this is something Sonia West has been kind of the leader in arguing for reawakening the press clause. And her argument is that the press clause, she views it differently than me. Her argument is that the press clause should include news gathering rights because those are distinct from free speech rights. So, for example, she would say you have a constitutional right to be free from punishment from refusing to comply with a subpoena to reveal your sources. And her argument is that it's not a problem to single out a narrow definition of journalists, members of the institutional press, because you always have the background of very broad free speech rights that everyone has access to. And so, for example, a protection against criminal sanctions for refusing to reveal your sources is very helpful to the national security reporter at the Washington Post. It's useless to me as a blogger because I don't have any sources. And so she argues that this background makes it not a problem. I personally would treat bloggers as speakers as opposed to members of the institutional press. Obviously, there's going to be some institutional press organizations that run blogs and employ bloggers, and those will look more like journalists. But, for example, I think Floyd Abrams has a pretty good play on Justice Stewart's famous "I know pornography when I see it" statement. Floyd Abrams says, "I don't think the court will have any problem identifying a journalist when they see one."
Yeah, I just wonder if they might have had a problem identifying Matt Drudge as a journalist when he reported on the Clinton affair, for example. It's a concern I have, but perhaps they could do it. I kind of need to know the standard when I saw it, and it's also the way you kind of illuminate it there is a different conception from other people who have been trying to imbue new meaning into the press clause, which is you say news gathering, or that one scholar says news gathering activity, when traditionally people have been trying to imbue new meaning into the press clause, I mean like publishing activity, because news gathering isn't necessary. I mean, it's a prerequisite in a lot of journalism to publishing, but it's not actual publication, because you might go through news gathering and not actually publish.
Right.
So that's another question I have, but I've got to run to a meeting, but I want to ask you one more question. Is there a way to conceptualize doctrinally the press clause in a way that doesn't create some sort of positive right? Which is to say, can it just require the government to clear the road from the press, not do something such as make all news gathering activity, for example, tax exempt? Or allow for news gathering activity to be tax exempt. And you do kind of see a lot of tax exempt news and nonprofit journalism now as a new model. And you also talk about how the government previously had allowed for postage stamps to be discounted for the press. That's something that I could kind of get behind, I think, in a more significant way than an affirmative requirement of the government to.
Right.
I don't know. I'm just wrestling, but even then, you still have to identify who is the press, and that is like a threshold concern for me.
Yeah, the question of who is the press has been, if you take the Supreme Court at its word, which I think you should because it's a sincere problem, that has been the sticking point in giving the press clause meaning. Is we don't know who the press is. We don't want to draw that line, because we're going to leave some people out who deserve to be in, and that's especially problematic in the context of the First Amendment. So that's always going to be an issue for anything that's attempting to give the press clause unique meaning, I think. There are conceptions of the press clause, of a renewed press clause that are based on negative rights. Again, Sonia West, her article, Reawakening the Press Clause, is about negative rights. Although I don't know how you would conceptualize a more robust constitutional right of access to government meetings and government documents and information, which a lot of press clause advocates support. That's kind of on the line between a positive and a negative right. But the news gathering rights that Sonia West identifies are primarily negative rights. Similarly, Lyle Denniston has argued that the press clause means absolute autonomy for the press, period. Kind of in a Hugo Black type of no law means no law mode. His argument is that, for example, like labor laws of general applicability cannot apply to the press. It's just too important. It's the press. It needs total autonomy, a sphere of absolute autonomy. And so my argument is that I don't think that either of those, in one sense, Denniston would go farther than I would. I think that labor laws should apply to the press.
Well, Lyle Denniston, like the Supreme Court reporter, long time? Or is
yes, I think so.
Yeah, he was like for 50 years covering the court.
It's a law review article in which he argues it. But, or it was like a lecture that was published in a law review, I think. But I guess in another sense, I think that neither of those goes far enough, which is securing the existence of the institutional press as a integral part of the constitutional structure.
Yeah.
And so if it disappears, that's a problem. And I don't see a way looking on the horizon outside of government action that protects the press.
Well, I don't see a way to protect the press. I mean, 100% sure thing it's going to exist outside of some sort of government funding, because you can clear the way as much as you want. You can make it as cheap as possible to do news. You can say, we're not going to tax you to the extent you have circulation. We're not going to make you pay for postage. Mm-hmm. But there are just terrible business people out there who can run any institution into the ground, you know? So, I don't know that there's ever a guarantee, but to the extent you can just make it as easy as possible, the libertarian instinct in me says, okay, just get the government out of, clear the government out of the press's way as much as you can, kind of likes that. But I don't ever know that you could guarantee it outside of creating like a government institution like the BBC. And of course, there's always concerns about doing that, as much as I enjoy the BBC. So,
right.
Anyway, I've got to run to this meeting, Luke. I appreciate you staying on the phone with me for almost an hour and a half. That article is The Broken Branch, Capitalism, the Constitution, and the Press. And when it's published, please do let me know, and I'll go back to this episode and link it in the show notes. But a lot to chew on here, and I really appreciate you coming on the show.
Yeah, thank you for having me. It's been a really great, illuminating discussion. Yeah,
we'll try to do it again sometime soon. This podcast is hosted, recorded, and produced by me, Nico Perino, and edited by Aaron Reese. To learn more about So to Speak, you can follow us on Twitter at twitter.com/freespeechtalk, or like us on Facebook at facebook.com/so-to-speak-podcast. Luke, I should also ask, do you have a personal website or something that we can give viewers to find more of your work, or listeners, I should say?
I don't think so.
Okay. Well, I'll just
look. You can search me on SSRN, and all my papers are up there.
Very good. Very good. And his name is Luke Morgan. But if you want to give us feedback, or if you for some reason can't find the articles, you can email us at sotospeak@thefire.org. We take in questions too, if you have one for a future show, at 215-315-0100. And of course, if you enjoyed this, please consider leaving us a review on Apple Podcasts or Google Play or wherever you get your podcasts, Stitcher, whatnot. They help us attract new listeners to the show. And until next time, thank you again for listening.